Dick, I'll try not to cut you off so precipitously.
Well, thank you very much. It's just a delight to be here. As Larry said, he was my student many years ago. He was a brilliant student. He's been a brilliant law professor. And I truly believe that this article, in conjunction with his piece on the fixation principle and his effort to identify the fixation principle and the constraint principles as the uniting core of originalism, really reflects brilliant work. I am not inside the originalist tent. I was somebody who had grown frustrated at a certain point that originalism just seemed to me to be a moving target. I didn't know what originalism was, what held these people together, and now Larry makes me think that I have seen something really important. And when I see the constraint principle and the fixation principle conjoined as the core of originalism, if that's right, then each of them has a kind of intuitive plausibility that makes me actually substantially more sympathetic to originalism than I had been before, or makes me think that I ought to adapt my own approach to make more accommodations to come closer to those two principles than I would have thought before. But it is customary in these things not for one to go on in adulatory terms, such as I have begun in. And so I will raise some criticisms and questions. But before I do, I just want to take note of, emphasize one of the features of the constraint principle, as Larry describes it, and that is, as he says, it's ecumenical. And because it is meant to be ecumenical, it is substantially vague or underdeterminate, so that I'm not sure exactly how it would cash out in principle. I take it in at least these respects. He says that it is consistent with there being multiple meanings. He says that it is consistent with there being construction, so that not everything we need to know about how the Constitution should be applied comes from the original public meaning. He says that the original public meaning, the constraint principle, is consistent with the notion that the original public meaning could be phased in over time, rather than something that would need to be done immediately. And then he says that there is an exception, if I understand correctly, for really extreme or extraordinary cases, without elaborating what would count as an extreme or an extraordinary case. So that's just by way of description. There's no intended bite to that description whatsoever, but it will be relevant to the rest of what I have to say. So now I want to talk about his arguments for the constraint principle. And here he says that the arguments that he wants to offer are shallow. And from my perspective, they are too shallow, so that I don't want to go so far as to say they're not pro tanto arguments at all, but they seem to me to be such very weak pro tanto arguments that I don't think they move me very much. And as I begin, I'll just begin with a puzzle that is a question. Larry, I'm sure, can address it in comments, but it's a genuine question. When he says that he wants to offer shallow justifications, I understand that as an argumentative strategy. He's right that it's an argumentative strategy that a number of other people have used defending other positions. But then once he says that he has adopted the argumentative strategy of offering shallow justifications, he suggests that anybody who wants to resist his argument is also limited to advancing shallow reasons for opposing it. He says it takes a shallow argument to beat a shallow argument unless you can persuade your fellow citizens that your deep argument is true. Well, if one wants to talk about what it it would take to persuade one's fellow citizens that a deep argument was true. I have no doubt that that is right. But just in terms of evaluating the persuasiveness of the arguments that he offers, it seems to me entirely possible for somebody to say, well, I'm not in the shallow justification mode. The shallow justification isn't going to move me. I've got some deeper grounds for resisting. Say, one other somewhat preliminary thing. In talking about the way shallow argumentation would operate, Larry says on page 39 of his draft, shallow reasons can be supported using the method of reflective equilibrium. We begin with our existing opinions about particular cases, intuitions, and hypothetical cases, and beliefs about general principles of constitutional theory. We ask whether the constraint principle itself and the justifications upon which it rests are consistent with those opinions, intuitions, and beliefs. Now, this is related to my thought about the justification being shallow, and for that reason, for my instinct, a little bit too shallow. When Larry actually gets into his justifications, the pro tanto arguments based on the rule of law and legitimacy, reflective equilibrium essentially falls out of the picture. It falls out of the picture because he insists, I think fairly enough, we often don't know what the implications of originalism would be for one or another case outcome and so forth, especially when the constraint principle is defined in the vague way that he defines it. But I'm left with considerable anxieties that the constraint principle is actually implemented could end up with results that I would find disturbing and that would bear on my reaction to the constraint principle pursuant to the model of reflective equilibrium. So then when we get into the shallow justifications based on the rule of law and legitimacy, I think that the argument is too shallow to be persuasive to me. One of the respects in which it is too shallow is that it just talks about the Constitution in abstraction from the going legal system in which the Constitution is situated. So when we think about the Constitution as situated in the going legal system, and we want to know what would promote the rule of law within that going legal system, then we would presumably be concerned with things like consistency, predictability, conformity to settled expectations that people have, and so forth. But we're denied the opportunity to assess whether originalism would actually, in rule of law terms, promote consistency, respect for settled expectations, and so forth, because we don't know what results it would dictate. The notion of the thinness of the rule of law comes through justifications, comes through to me with special power when Larry distances himself from Will Bode's argument that originalism is the law. Because if originalism isn't the law, then there's a certain oddity about offering a rule of law justification for rejecting what now is the law in order to arrive at some other mode of interpretation that isn't currently the law. I don't say that it couldn't be done, but it would be a complicated argument, and I don't see that argument being laid out. I could say similar things about legitimacy and the things that Larry says about legitimacy. Not that they're bad arguments, but they seem to me to be actually quite weak as pro tanto arguments, or only weakly pro tanto arguments because of their shallowness. The last thing I'm going to try to squeeze in, if I can say this in a minute and a half, is that I think that Larry's piece is brilliant about showing me what unites originalists. I don't think it actually brings out what divides originalists from non-originalists. I'm not sure whether that's a criticism. It's certainly an observation. It seems to me that if one wants to know what divides originalists from non-originalists, I would think the divisive issues would be how good or bad results measured in terms of change from a current baseline we would get if we move to originalism, and how determinate a theory of interpretation should be, or how much wiggle room it should leave for people who are worried about untoward results in particular cases. Larry brackets both of those issues. Again, I don't mean that as a criticism. This project is just to identify what unites originalists. I think it doesn't much advance the debate as between originalists and non-originalists, save in this important respect. The paper, together with the paper on the fixation principle, are just so clear and powerful in their exposition of what fixation is and what constraint is, and the intuitive appeal of those two principles is so powerful once they are laid out with the clarity and precision that Larry lays them out with, that, as I said at the beginning, and I'm very genuine in saying this, he makes me think I have to revise my position to come closer to what he calls fixation and what he calls constraint than I would have thought before.
Well, thank you for those very generous remarks. So let me just respond to three of the very illuminating and helpful things that Dick said. First point, so are the arguments that are offered in terms of the rule of law and legitimacy so shallow that they are weak? Right, so I think that I would just slightly disagree with the diagnosis here. It seems to me that if these arguments are weak, it's not because they're shallow, it's because they're not fully fleshed out at a more concrete level with examples. Right, so going shallow means not appealing to a comprehensive theory of political morality, utilitarianism, or Kant's theory, or any other, or Locke's theory. And the reason that the paper does that is because adopting any one of those frameworks as your basis for justification will then automatically mean that most of your fellow citizens will reject the reasons because they don't accept the underlying deep theory. The weakness, I think, that Dick identifies stems from the lack of sort of concrete examples. And I just think that this is a valid criticism of the paper, that the descriptions need to be thicker for these arguments to be fully persuasive. And I understand that there's much work to be done at that level. Second thing, about reflective equilibrium dropping out and the lack of attention to concrete results. This is a function of the same issue with the paper, that it's argued in an abstract way, not a concrete way. I think I need to address that. However, I don't think that that is entirely a function of reflective equilibrium. So there's a common misunderstanding of reflective equilibrium that in Rawls's sense, and that's the sense that I'm appealing to, that sort of says that the data points are all concrete particulars, and then we reach reflective equilibrium on general principles. That's just not what reflective equilibrium is. Reflective equilibrium is equilibrium between all of our considered judgments at all levels of generality and abstraction. So the lack of concrete examples is a serious problem with the paper, but it's a different problem than not employing the method of reflective equilibrium. So the final thing I would like to talk about is just this question about the division of originalists from non-originalists. And I thought that the way that Dick framed this was particularly useful for my purposes. Dick sees this as a matter of looking at the status quo and then comparing originalism to that, right? And the first thing I want to say is this is just not the structure of normative theoretical debate about originalism and various forms of living constitutionalism, because the status quo is something that almost no one wants to defend. The status quo I characterize in the paper is best characterized as constitutional eclecticism. This is not pragmatism. This is one judge is an originalist, one judge is a common law constitutionalist. Most judges have no understanding of what method they're using, and they use different methods on different occasions as it strikes their fancy. That does not seem like a coherent constitutional practice. Pairwise comparison, which is the only way I think to make progress here, requires that we look at the issues raised by each of the serious alternatives to originalism. That's just different for Thayerianism, common law constitutionalism, Posnerian pragmatism. These are all very different theories with different normative considerations bearing on the pairwise comparison.